Now I am going to dictate a legal passage based on latest Supreme Court judgment at the rate of 120 words per minute. Let's start. The proceedings under Article 32 of the Constitution address a challenge to the validity of the enrollment fees charged by state bar councils. The grievance is that the fees charged by the SBCs at the time of the admission of persons on state rolls are more than the enrollment fee prescribed under Section 24 (1) F of the Advocates Act 1961. The Advocates Act was enacted to amend and consolidate the law relating to legal practitioners and constitute a common bar for the whole country. The enactment establishes the SBCs and the Bar Council of India. Section 6 of the Advocates Act entrusts myriad functions to the SBCs. These functions comprehend entry into and conduct of legal professionals, including admission of advocates to their roles, preparation and maintenance of roles, determination of cases of misconduct against advocates on the rolls, and safeguarding the rights, privileges and interests of advocates. The statute empowers the SBCs to organize legal aid for the poor, promote and support law reform, conduct academic discourses and publish journals and papers on matters of legal interest. The functions of the BCI have been enumerated under Section 7. These include laying down standards of professional conduct and etiquette for advocates, enunciating the procedure to be followed by its disciplinary committee and the disciplinary committee of the SBCs, safeguarding the rights, privileges and interests of advocates and promoting law reform. BCI is empowered to exercise general supervision and control over the SBCs. BCI is also empowered to impart legal education and lay down standards for legal education in consultation with the universities whose degrees in law would be a qualification for enrollment as an advocate, and for that purpose visit and inspect universities. Chapter 3 of the Advocates Act pertains to the admission and enrollment of advocates. Section 17 mandates the SBCs to prepare and maintain a roll of advocates. An application for admission as an advocate on a state roll is made to the SBCs. The SBCs are required to issue a certificate of enrollment to every person whose name is enrolled in the roll of advocates. Section 24 prescribes the qualifications and conditions for a person to be admitted as an advocate. To qualify to be admitted as an advocate on a state roll, a person must (small a) be a citizen of India, (small b) complete the age of 21 years, (c) obtain a degree in law, (d) fulfill such other conditions as may be specified in the rules made by the SBCs under Chapter 3, and (small e) pay an enrollment fee of rupees 600 payable to the SBC and rupees 100 to the BCI, along with any stamp duty if chargeable. In the case of a person belonging to the scheduled castes or scheduled tribes, the enrollment fee of rupees 100 is payable to the SBC and rupees 25 to the BCI. The SBC's charge enrollment fees stipulated under Section 24 (1) F of the Advocates Act to admit law graduates on their state roll. At the time of enrollment, the SBCs also charge various fees and charges in addition to the enrollment fees in the form of library fund contributions, administration fees, identity card fees, welfare funds, training fees, processing fees, certificate fees, etc. The amount of fees charged by the SBCs differs significantly. This results in a situation where a law graduate has to pay somewhere between rupees 15,000 to rupees 42,000 (depending upon the SBC, as cumulative fees at the time of enrollment. There, the petitioner instituted proceedings under Article 32 of the Constitution seeking a declaration that the fees charged by the SBCs at the time of enrollment. Stop. Thank you.